Good afternoon and welcome to Legal Matters. My name is Tulani Mututa, orator for the law. I am your host and we're coming to you live and direct from the Heart and Soul Broadcasting Studio Services Station in the heart of the capital, Harare. Today I am joined on Legal Matters by a man who needs no introduction, who is preceded by the work he has done in human rights law, Mr. Douglas COLTART, a human rights law expert. And today we're going to be talking about a particularly different but interesting topic on Legal Matters, which is coined Exonerate Criminal Justice in Zimbabwe. Mr. COLTART, welcome to Legal Matters. Please introduce yourself.
Thanks so much, Tulani, and great to be on the show. Introduce myself. Okay. I'm a lawyer. I do a lot of different types of matters, but I've been involved in a lot of human rights cases and criminal defense, particularly those who we consider to have been arrested, detained primarily for the exercise of their rights, whether they be journalists, trade unionists, activists, students who are arrested for the exercise of their rights. So that's kind of my day job.
Okay.
I am also, I'm a citizen, a proud Zimbabwean and very passionate about the role that ordinary citizens can play in creating a better society, in effecting change in our communities and in our society. And I am a Christian. That is really, I can say, the foundation or the driving force behind the work that I do is the belief that, I serve a God of justice who demands that his people also stand up and fight for justice and speak out for those who are downtrodden and oppressed.
Yes, wow, interesting introduction there, Mr. COLTART. And we really are glad to have you on Legal Matters, and we cannot express in words how much we appreciate that you have taken time out of your schedule to join us as we talk about something, like you said, that goes to the heart of humanity, criminal law and criminal justice. So these are some of the notions we're going to try and define today on Legal Matters, on what justice is, on what the criminal system is. Because as you will find, the police or the executive as an arm of the government is there to enforce the law. So if you violate the law in any way and you're found criminally liable, you will surely go to jail. So we're going to be understanding how exactly that criminal justice mechanism works in Zimbabwe. And before we get to that, we are also going to make sure that we make people understand the essence or the importance of human rights in criminal defense. Because like Mr. COLTART said, criminal defense is a mechanism that may be used to suppress people's rights, which is why there is that need to make sure that lawyers like Mr. COLTART stand in that divide and advocate for criminal justice in a world-class system in Zimbabwe. So we have 3 exciting segments today on Legal Matters, and we are just going to ask Mr. COLTART once again to explain what exactly the criminal system or what the criminal justice system is meant for, or the purpose really of having criminal law in Zimbabwe. Because you find that Legal Matters is also passionate about the issue of legal awareness. And in being passionate about legal awareness, we need to make sure that the people we are communicating to understand what exactly it is that we are communicating about. So what exactly would you say is criminal law, or what exactly would you define as the criminal justice system in Zimbabwe?
Yeah, sure. So, basically the criminal law, the legislature comes up with legislation saying, don't do X, Y, and Z. If you do, it's a criminal offense. These are typically these are things which, as a society, we have decided as a community that these are things which we don't want people to do. The obvious ones being things like murder, theft, etc.
Yes.
But a lot of our criminal laws are codified in an act called the Criminal Law Codification and Reform Act.
Okay.
So most criminal offences can be found in that act. Not all of them are. Some of them, for example, things like COVID regulations also might contain some criminal offences. You might find some in other legislation. But the criminal justice system is then how those criminal laws are enforced.
Okay.
You've mentioned the police. The police play a very important role in enforcing the criminal law, in apprehending those who violate it. And when we're now talking of criminal justice, we're now speaking of the whole system that's in place to try and ensure that only those, number one, that the process by which people are found to be guilty of a crime is a fair one, and is characterized by justice.
And by that, you're trying to say someone cannot be found criminally liable for something that is not a crime in terms of the criminal code.
Exactly. So you shouldn't be found guilty of something which maybe wasn't a crime at the time that you committed it.
Okay.
I just managed to get a client off on a COVID charge, where he had been charged with something under the COVID regs, and then those regulations were repealed by new regulations. And so those regulations no longer existed.
Yes.
And then they still were trying to prosecute someone for a crime which no longer existed
as a crime. Yes.
And the law doesn't allow that.
Yes,
right.
Yes,
so it's those sorts of things, not being prosecuted for something, for a crime which doesn't exist.
Yes.
And even, I think we'll get into it a bit later, in terms of ensuring that some of your rights, in terms of how the whole process goes, that you are not tortured in order to extract a confession from you, etc., etc.
And also, we'll be really keen to talk about the issues of a fair trial, and also what constitutes a fair trial, because
precisely,
yes, what we're trying to do from this show is to ensure that the ordinary Zimbabwean is empowered, and empowered in that they know their criminal justice rights. So there you have it, folks. I am coming to you live and direct from the Heart and Soul Studios. I am with Mr. Douglas COLTART, a human rights law expert, and we're talking about the criminal justice system in Zimbabwe, Exonerate. So we'll take a short break, and we'll be right back on legal matters as we jump into the first segment, Law Watch, where we'll be talking about electronic justice mechanisms in Zimbabwe, and also the effect of the recent COVID-19 influenza pandemic on the administration of justice within our courts in Zimbabwe. So stay tuned to Legal Matters. The law is in action. Good afternoon. My name is Tulani Mututa, orator for the law, and we are back on Legal Matters, where I am joined today with Mr. Douglas COLTART. So we are now getting into our Law Watch segment, and we're going to be talking about the current affairs aspect of the effects of COVID-19 on the administration of justice within our criminal courts. So, Mr. COLTART, as history has it, or as time has proceeded so far, the pandemic of COVID-19 has basically changed the way that life was lived before it, in terms of the use of technology, in terms of the way we do certain things because of the restrictions that were imposed by the lockdown regulations. So what exactly was the effect of COVID-19 on the administration of justice? Because I can understand that the courts that had to deal with civil matters were closed down during the lockdown period. But then what about those courts that were dealing with the liberty of people? Because I understand that the criminal justice system is something that does not function from a period, but then is constantly in action. So what then was the effect for those people who had been arrested during the COVID-19 period or pre the COVID-19 period with regards to their cases, because of the issue that the courts were not functioning as normally as they did before COVID-19?
COVID-19 had a huge impact on the legal system generally, and particularly the criminal justice system. I think the courts were really the criminal courts were overwhelmed with cases. There was thousands of people being arrested all the time, and I mean, as an aside, I think a lot of us really felt that it wasn't the best way to really encourage the slowdown of the spread. There were maybe better ways of doing it than locking people up and then having hundreds of people in cells and spreading the virus. And it put a huge amount of pressure on the criminal justice system.
Yes, and also with regards to that pressure, I remember being in court and personally witnessing where an accused person could not be admitted to bail or could not have their bail application heard just because of the backlog of cases that the magistrate had. And this is understandable, Mr. COLTART, as a legal practitioner yourself. You can understand that these issues have to do with the liberty of people.
Yep.
So the magistrates cannot just rush through these cases. They have to take their time and apply their legal minds.
Yep.
So what exactly can you say was the effect of COVID-19 on the judicial in terms of administrating justice?
Yeah, it certainly was a huge challenge, and we're lucky now that things have slowed down a little bit. But I think we have certain mechanisms in place which require that particularly bail matters, as you've spoken about, which deals with the liberty of the individual, need to be dealt with on an urgent basis, and so that someone is not locked up unjustifiably for a long period of time.
Yes.
And so that huge backlog meant that sometimes people's rights in that regard were being violated.
Yes.
And in other instances where the court system was just so sort of overwhelmed that there was I can say there was a leaning towards at some point, I think when they realized the problem, a leaning towards let's move away from just detaining people en masse and rather use the regulations in place to encourage people maybe to go home. If you catch someone breaking the COVID regulations, rather go home than arresting them and putting extra pressure on that system.
Yes, and that's also quite something that you have brought up, Mr. COLTART, because as you're saying, the administration of justice does not just begin with the magistrate on the day of reckoning, but it also begins with the arresting details. It begins with the police officers. They are in essence going to be the custodians of administering this criminal justice. And that does not only just go to the way that they respond to the crimes, but also, as we'll talk about in the last segment, as how they treat the people they would have arrested as well. So in response to the backlog and the cases that were coming up to the judicial system, the Judicial Service Commission in Zimbabwe decided to follow the example of so many developed countries out there and launch its first ever project of electronic justice mechanisms. So what exactly is the wave with electronic justice mechanisms? What exactly is the situation with regards to implementation, and what is it all about?
Yeah, so I think globally, the world is moving in that direction, or legal systems are moving in that direction, and it makes sense because there's so much of our lives now that we do electronically. We send emails more than letters. Although the legal profession, I think, is stuck in the past. The lawyers still love to send letters. And so I think that is the idea, to say that the filing of court processes, and by that we just mean the legal papers that you file at court, should all be, we should be able to do that electronically. We should even be able to serve the other party electronically.
Yes.
Now, in terms of in terms of the criminal justice system, that pretty much is non-existent.
Yes.
In terms of the civil processes, it is being implemented in a sort of phased approach.
Yes.
But in only in fairly limited context. I understand the Chinoi court you mentioned.
Yes.
Is focused on that. I don't. I have never appeared before the Chinoi court, so I haven't experienced that. And the commercial court as well has some some rules in terms of filing of electronic documents. But it's still very early days, and I think there's a lot of kind of growing pains, which we still need to iron out before it really would be rolled out effectively. But it certainly is a step in the right direction.
Yes, it definitely is. And like you're saying, the world is changing and the law needs to change ahead of the world. One thing as well that I would also just like maybe to say for our guests and for our listeners out there to just bear in mind is how exactly technology has also been used in other jurisdictions to try and help people who have been convicted of their crimes or who are in the process of having their crimes adjudicated have access to legal information.
Yeah.
Because you find that one computer can carry so many information about the law that inmates who are not represented by legal practitioners would need. And even those that are represented by legal practitioners would also need to know to understand how exactly their case is proceeding in terms of the criminal adjudication process. So it's definitely something we need to look into, providing electronic resources, legal electronic resources to people who need them the most, and make sure that they are available in the places that they will have the most drastic impacts to improve the access to justice. So,
absolutely.
Yes, there you have it, listeners. Our Law segment was of that interesting topic on electronic justice mechanisms. And since the president is already spearheading he's the one who officially opened the Chinhoe Court, he is also spearheading the movement to have electronic justice mechanisms across the country. So we'll really be interested to see what else the Judicial Service Commission will be doing with regards to dispensing justice electronically. So thank you very much, Mr. COLTART, for your insights on that electronic justice mechanism. Maybe what we can do now is just take another short break and come back and head into our Legal Wise segment. And in the Legal Wise segment, we're really going to be breaking down criminal law and criminal law procedure so that the listener understands the procedure from when you are arrested to when you are arraigned before a magistrate, whether be it the bail procedure or finalization of that matter. We are going to be getting into Criminal Law 101 with Mr. Douglas COLTART. So stay tuned and we'll be right back after the break and we'll be catching the law in action with Mr. Douglas COLTART. Good afternoon. We are back on Legal Matters and we're now getting into our Legal Wise segment where we are going to be talking about criminal law and criminal law procedure in Zimbabwe. What we want to do with this segment is to make sure that we spread as much legal awareness with regards to the criminal law aspects as much as possible. So Mr. COLTART had already given us an icebreaker as to what the criminal justice system is all about. One would basically say that the criminal justice system was created to basically make sure that there was peace between men, to regulate some of that human conduct or human behavior that may have effects on the next person that you live with. So now let's get into criminal law. Mr. COLTART, how exactly is criminal law in Zimbabwe structured? You had mentioned that there's a piece of legislation that regulates it, but then what exactly is the objective or the purpose of criminal law, as you were saying in the icebreaker segment?
Yeah, I mean the purpose of criminal law is really to guide, as you mentioned, as to guide human conduct, so that we interact in ways with one another that don't harm one another. So in terms of the criminal law is really divided into, you've got substantive criminal law, I mentioned the criminal code, and then procedural criminal law. So that's primarily contained in the Criminal Procedure and Evidence Act. This is the act which governs how the whole criminal justice system works, etc.
All right.
There are some other aspects, but those are your two main pieces of legislation that govern how the criminal law works.
And what would be the main difference between the two, in that the substantive law has the rules per se and the procedure has how those rules are applied?
Yes, exactly. So rules in a non-legal sense. So the criminal code is the one which will list actual offences. So you'll have in there murder, theft,
Yes.
and then the other favorite ones like subverting constitutional government,
Yes.
and the one I was once charged with,
Yes.
what is it? Participating in a gathering with
Yes.
intent to promote public violence, breaches of the peace, and bigotry.
Yes.
That sort of thing is in the
Yes.
code, right? These are the criminal
The
offenses,
substantive,
the
yes.
substantive.
Yes.
Then in the procedural act,
Yes.
that's where the procedure in terms of how it all works. So this is where the procedure for applying for bail is set out. This is the procedure which the police are meant to follow in terms of when they arrest you, etc.
Yes. And you've brought up something that's quite interesting there, or something that I'm passionate about talking about. The bail procedure. Is bail a constitutional right? What exactly is the purpose of bail? Because the other thing as well that we need to understand is most people now think that bail is a way for people to get away scot-free when they've committed a crime. Because I'll give a basic example of a community where a girl child may be raped. And after the girl child has been raped, 2 weeks, we see the person who allegedly committed that rape back on the streets. So now there's that whole misconception by the general public that bail is like a get out of jail free card for the people who can afford to pay it.
No, that's a really important question and point to raise. So our starting point is that that everyone is presumed innocent until proven guilty, and you're only proven guilty at a criminal trial where the state has proved their case beyond a reasonable doubt. Now it takes a little while for the state to gather all the evidence, etc., and take it to criminal trial. And so in the waiting period between someone being arrested and actually going to trial, that is where the question of bail comes in. So if someone is granted bail, it's not that they are getting off scot-free, because the idea is that they should still have their day in court where they should go to trial, and if they're convicted, then they might still have to serve a prison sentence. The question at bail is primarily a case of, will someone stand trial? If they, if we let them out of custody, will they actually pitch up for their trial, or will they disappear? Will they interfere with the investigations, or particularly, you mentioned in cases like rape, etc., whether there's any threats maybe to the victims of that. So those are the questions which the court is really considering when it comes to bail matters. Bail is a right. It's a right partly in terms of the right to liberty, which says that no one should be detained without a trial. And in terms of Section 50, which is the rights of arrested person, it also sets out that no one should be detained unless there are compelling reasons to do so. So like most rights, it is a right, but it's not an absolute right. There may be circumstances such as what we've been speaking about. If someone is unlikely to stand trial, if they're likely to interfere, where they can be denied bail.
What about the seriousness of the crime, Mr. COLTART? Because surely we cannot let someone who was, like what you're saying, trying to subvert a constitutionally elected government to walk scot-free, because that is a serious crime, and we cannot certainly be giving bail to people like that. What does the law say?
You sound like some magistrates that I've come across. So the seriousness of the crime is a factor to take into account, but it's only really a factor to take into account in conjunction with other factors, right? It might be taken into account as to whether someone is likely to flee the country if they're facing a very serious offense, which potentially carries a very long prison sentence. So to that degree, it is a factor that the courts can take into account, but it's not really a decisive factor, because at this stage, we must remember that this person is innocent until proven guilty.
And Mr. COLTART, I really think you cannot hammer any more about that, because that presumption of innocence, like you were saying, may stand to be the backbone of the criminal justice system.
It is.
Because we are saying someone can only be found guilty in terms of the rules. So if they're not found guilty in terms of the rules, then at least they should have that presumption working for them. But is it always the case? Because in as much as there may be that presumption of innocence, there are those serious crimes like what we're talking about, where media may have already painted the picture or made a conclusion that this person may actually be guilty and there is compelling evidence. So where exactly does the right of that presumption of innocence stand? And can it win the day in the bail court?
Well, it needs to, and we need to keep fighting for that. That's not to say that everyone should be granted bail. Certainly, there are circumstances where it's inappropriate for certain persons to be granted bail. But a lot of the cases where we see people being denied bail are not those cases. Such as what I mentioned in the beginning. Cases where people are arrested for exercising their constitutional rights. Those certainly are not cases where people should be denied bail. And there has been a worrying upsurge in the in the so-called Second Republic, where we have seen more of this denial of bail, or the weaponization of denial of bail as a way of punishing people before they've even been convicted of any offense. And so that is certainly something that that we need to push back on. The High Court has been pushing back on that in terms of the practice which we've seen in the Magistrates Court in particular, where bail is denied routinely in certain types of cases,
only to be granted by the High Court,
only to be later granted by the High Court. But it's a worrying situation where you see the lower court, the Magistrates Court being the lower court, continually denying bail and then being told at the High Court that you've grossly misdirected yourself. But instead of then correcting what you're doing, the very next case comes, you do exactly the same thing. That's a very worrying situation.
It is, and especially since, like you said, our criminal justice system is standing on such guarantees. So if someone is innocent until proven guilty, then certainly they must be allowed that privilege or that perk to bail. And after all, like you said, it's not granted blindly, but then there are serious considerations that the courts take into account before someone is granted this bail. Well, Mr. COLTART, I really hope our listeners are getting to understand the mechanics or really how bail works, and also just that crucial issue you're talking about weaponization of the criminal justice system. One thing I would like us to now get into, Mr. COLTART, is the test for guilt in this criminal justice system. You said a phrase that caught my attention: beyond reasonable doubt. Mr. COLTART, what exactly does that mean?
So, essentially, so there's two what we call standards of proof in the civil matters, and it's helpful, I think, to compare them. In civil matters, where maybe I sue you because you breached my contract, etc., the standard is on a balance of probabilities. So the court should just listen to my story, listen to your story, and say, I think I believe Doug a little bit more than Tulani. On a balance of probabilities, I think I'm gonna grant Doug's application. In criminal matters, the standard, as we've mentioned, is beyond a reasonable doubt. And what this really comes to, it's very much grounded on the presumption of innocence. And it comes from a position of saying that liberty in particular is such an important thing that we as a society don't want to lock up innocent people. It's better that 10 guilty people go free because we have a high standard than one innocent person spends the rest of their life in jail for an offense that they didn't commit. And so we have this high standard beyond a reasonable doubt. And just as the words imply, the idea is that the judicial officer, when they weigh up the case by the state, and they weigh up the case presented to them by the defense, they should have almost no doubt. They should be, I can say, almost 100% convinced that the state clearly has proved their case. Definitely, this person has committed the crime. We say beyond reasonable doubt because there can always be that doubt in the back of your mind, or you can raise some spurious story that the aliens came down and they're the ones who did X, Y, and Z, and of course we can't categorically discount that the aliens came down. But it should be at a point where there's no reasonable doubt in the mind of the judicial officer that this person committed the offense.
I like the way that you use the alien because really some of the judgments, also really some of the way that these decisions arrived at seem alien, because as the public, we will really scratch our heads and try to understand how exactly such a decision could have been arrived, especially in criminal matters. So in terms of this assessment of beyond reasonable doubt, what things are considered? Maybe say the evidence that's at hand. How exactly does that evidence has to be? Does it have to be overwhelming evidence? Does it have to be concluding? Say maybe it's a possession crime, and that person is found with that substance that they're not allowed to have. Maybe say it's a weapon. Is the evidence supposed to be overwhelming? Is there only supposed to be a medical report when someone is convicted of a crime of rape and the medical report is proving penetration? What exactly is the evidence yardstick when it comes to this issue of beyond reasonable doubt?
Yeah, so look, I mean, that is really going to depend, on a case by case basis, the nature of the crime, etc. But yes, evidence is the crucial question before the court, and the court needs to weigh up the credibility of that evidence. Or number one, the admissibility of that evidence, because evidence, for example, maybe evidence that's obtained illegally via torture or something would not be admissible. So there's the admissibility of the evidence, and then there's the weight to be attached to evidence. Now, evidence can come in the form of, as you've mentioned, it might be a medical report, it could be documentary evidence. But there's also, of course, oral evidence. So that's when various people witnesses take to the stand. They go under oath, and then they tell their side of the story. Now, that is evidence. Sometimes people say, there was no evidence, they were just saying things. That is evidence. But the judge or the magistrate needs to weigh up the credibility of each of the witnesses and say, for this reason, this witness appeared to be credible, and I believe the evidence that they gave. Or for whatever reason, given the demeanor or the contradictions in their story, I don't think that this witness was credible, and so I'm not going to attach much weight to that evidence.
All right. Well, thank you for that. And really, that classification, I felt like it was really important, because the general public needs to understand that when a witness is on the stand, they are under oath, and that evidence is treated with a certain weight or certain credibility that is attached to it. So one question I really wanted to find out on this particular segment was, what exactly constitutes a fair trial? But from the deliberations we've been having, I think I have somewhat of an answer. So I'll just go ahead and pose it before you. What exactly now would constitute a fair trial? Say that someone has been arrested, they've gone through their 48 hours at the police station, they've been arraigned before the magistrate, and the trial has gone through. What exactly, or what elements would you consider to make it a fair trial, considering some of the issues that you've been raising, like torture and admissibility of evidence? What exactly in your mind would constitute, or maybe according to the legal provisions we have at hand, would make a fair trial?
I mean, there's a whole range of factors which we probably don't have time to go into all of them. But I think probably the most critical element of a fair trial is that it should be before an impartial tribunal. Before an impartial judge or magistrate. The judicial officer should not be invested in the matter. They should not be fighting on one side or the other. They should be stepping back as an impartial arbiter. So that's one of the really critical aspects.
And also, just touching on that critical aspect before we move on, just because I feel like this is a really hot issue in terms of dispensing justice. the issue of corruption on the judicial system on its own, because like you're saying, the judicial officer has to be independent and the tribunal has to be independent. So what now really becomes the issue with things like corruption? Because I understand we have organizations that have been set forth by the government, but really at the end of the day, not all of the judicial members or the judicial system on its own is insulated from corruption. So what exactly would you say would be the way that, as a human rights expert, you think would be best to handle around the corruption issue, and also just as a recommendation on solving it as a prevailing problem within the justice system?
Yeah, I mean, corruption within the judicial system is one of the biggest threats to the right to a fair trial and to generally a credible legal system. And the way to address that is, it's a difficult one. I mean, I think, most importantly, we need, at the end of the day, we need judicial officers who are men and women of integrity.
Okay.
Because at the end of the day, they are the ones who need to resist the temptation to accept bribes. And, and so they do need to be better mechanisms for going about that. And I think it's concerning that with some of the constitutional amendments, there have been attempts to whittle away and to strip down the process by which we try to ensure that men and women of integrity are appointed to the bench. The interview process is an important one. The role of an independent body and the independence of the JSC in that process is an important issue, and the fact that is being stripped down and that power is being consolidated in one individual being the president is very concerning, and it's not a good sign for the direction that our judicial system is taking. So I think having men and women of integrity is critical. Then we need effective anti-corruption bodies. The Anti-Corruption Commission, the police, etc., that investigate allegations of corruption, need to play their part. And then, of course, we can't run away that we as lawyers have to also play our part, because often lawyers are complicit and are involved in corruption. And that needs to be weeded out. And lawyers who are caught involved in corruption, need to be dealt with and to be prosecuted.
Well said, Mr. COLTART. And really, it's not only the lawyers, but then it's the entire justice system, because we are even talking about the prosecutors as well.
Exactly.
So really, the clarion call is for everyone who is an administrator of justice in the judicial system to really make sure that they are serving to meet the ends of justice and ensure that the trial is as free and the trial is as fair as possible. And also that there are no things that may make one party in that dispute, or one party, maybe be it the state or the defense, have a better hand of proving their case before the court.
Well, actually, while we're on that, just for your listeners as well, that because citizens play a role in this as well. And citizens should know that you don't need to pay
for justice.
And sometimes it's longer, sometimes it's harder, but you don't have to. I can honestly say to you here that I have never paid any bribe, and none of my clients have paid any bribe, and yet ultimately, my clients have ultimately been granted bail. Sometimes they've been locked up for some time. But we as individuals have to take a stand and say, even if it means that I get risk to the get exposed to the injustices of the system, such as some people who get locked up unjustly and unfairly, that is a price that we should be willing to pay in order to build the society that we want. Because if all of us just say, That's how the system works. I'm just going to pay for justice.
Yes.
Then the whole system breaks down, and
Yes.
then what's the point of even having a court system?
Yes. Well said there, Mr. COLTART. And really, like I said before, you are an inspiration to so many human rights experts out there because of that fact that you're willing to take that stand and even willing to get imprisoned as well, to believe and work on that world-class justice system that Zimbabwe can have, and that people like you, Mr. COLTART, are building in Zimbabwe. So we'll take another short break and come back and round up the show as we get on our law in action segment, where we're just going to be talking about the importance of the rights of the accused and just generally rounding up the show on the world-class criminal justice system in Zimbabwe. So stay tuned to Legal Matters as we catch the law in action. Good afternoon, listeners. We are live on Legal Matters, and I am joined today in the studio with Mr. Douglas COLTART, a human rights law expert, a man who is passionate about defending the rights of the innocent until they are proven guilty. So we are now getting into our last segment, where we're just going basically to round up the show and try and explain some important tenets about the criminal justice system in Zimbabwe. And one such thing is the rights of the accused. Mr. COLTART, I myself have been personally arrested for COVID charges and, miscellaneous offenses. And I've had to deal with the police. And in dealing with the police, I've had to really question myself to really understand whether I have rights once I'm in the hands of the police. And also, just being someone who's knowledgeable about the law, you may not want to seem like you are overusing the law, or you are not respecting the police in their administration of justice or in doing their duties and their roles. So what exactly is this issue with regards to the rights of the accused or the rights of detained person? When you are in the hands of the police, do you lose your human dignity to such an extent that you have no rights whatsoever that protect you?
Absolutely not. So everyone has rights, and the Constitution explicitly sets out rights for arrested persons and rights for accused persons. That's in Section 50 and Section 70 of the Constitution. And let me say right from the outset to your listeners that make sure you have a copy of the Constitution. Have it on your phone. Have it. You can get it readily available online and read through those sections so that you know what your rights are. So, your rights as arrested persons. Number one, you have a right to remain silent. And by remaining silent, you are not admitting to guilt or anything like that. And the police might tell you, if you don't speak, we will use it against you. But you have a right to remain silent. You have a right to be informed promptly of the charge, and the grounds on which you have been arrested. A lot of the time, we find that people are just detained and locked up for a number of hours, and they've got no idea even what the charges are.
Only to be released later on.
Released later on, which is
some form of torture or harassment.
Yeah, exactly. I mean, that's an important. You have a right not to be tortured. Even, and this is an important thing, which I think we also, as a society, need to understand. Even if someone is guilty of an offense. Even if they've done some heinous crime. There is absolutely nothing which ever justifies torturing someone. No matter what they've done. We don't have to torture them. We punish them by way of putting them through a fair trial and them being convicted and they serve their sentence. We don't punish them by torturing them. You have a right to be brought before a court within 48 hours. And a lot of the time, again, we see this being violated, often. And citizens need to know these rights and to enforce them. And to demand them. You have a right to a lawyer of your choice. And this is throughout the legal process. I mean, I'm sure you remember this was the thing which came to the fore in one of Hope Chingono's cases, where his lead lawyer, Beatrice Mteto, was removed from the case.
Yes.
And the High Court intervened and said, no, an accused person has a right to a lawyer of their choice. No one can determine, you can have this lawyer, you can't have that lawyer.
Yes.
So, there's a lot of other rights in there.
Yes, and I also think that right to legal representation is really important, because once you are legally represented, you now have a boxer or a coach in your corner who is telling you that this is not allowed. If you're tortured, that's not allowed. You have to be out of here in 48 hours. Someone who knows the law and is ready to assist you. But you may find that one problem we have as a society is that most people may not be able to afford legal representation. And I understand there's something called legal aid. And I understand you have also worked for Zimbabwe Human Rights Lawyers Association doing some of this work for criminal defense without any remuneration. What would you think, or what would you say to the lawyers out there with regards to this issue of free or pro bono legal criminal defense? Is it only an issue for the lawyers, or it's an issue that society has to come together and accept by creating civic organizations that deal with dispensing justice to the people who need it the most, but sadly cannot afford it?
Yeah, that's absolutely true. It's a really having a lawyer, being legally represented is such an important right that I think we as a society need to really work to ensure that that's a right that is not denied to anyone on the basis that they can't afford.
Yes.
So Zimbabwe Lawyers for Human Rights is a very important resource, and people should look that up, look up their contact details online, etc. Save it in your phone.
Yes.
If you are arrested for particularly, these cases where we're saying people are arrested for exercising their rights.
Yes.
Then, that's the sort of case that ZLHR can intervene in.
Yes.
They can't, of course, intervene if you're arrested for committing actual crimes, etc.
Yes.
But a lot of the time, they can intervene, and it's important for people to know that those resources are
available. There. Yes.
There's also provision for state-assisted legal representation, especially in serious offences. That where people can face life imprisonment, etc.
And examples would be, I know of murder, for instance.
Particularly murder is the main one where people are generally provided with a lawyer at state expense, or there's a pro bono roster that all lawyers have to do a certain amount of pro bono hours during the course of their career.
Yes.
And lawyers get called up from time to time to take these pro bono cases. But I think we need to really develop a culture within our legal profession of providing pro bono legal services above and beyond that which is required by the roster system. And as you mentioned as well, I think there's a need for creating associations, etc. that can provide
issues of legal aid, particularly with regards to criminal defense. Yes. Well, like you said, Mr. COLTART, these are the rights that my listeners and anyone out there in Zimbabwe needs to know whenever they encounter or whenever they have a criminal matter that they are involved in. So just to round up the show, Mr. COLTART, you have experience both in the legal profession, in the civil world, and in the criminal world. And you have experience as well by just being a Zimbabwean. And you know that no one is above the law. Anyone can be arrested for the commission of a crime. So what exactly would you say, just maybe as a parting shot or as a conclusion with regards to the administration of criminal justice in Zimbabwe, that may just empower someone one day when they really need it?
First and foremost, know your rights.
Yes.
So before this show ends, people go and download a copy of the Constitution onto your phone. Read it. Read especially Chapter 4, which contains all of your rights. And for the purpose of this conversation, look in particular at Section 50 and Section 70. So I think that's the biggest takeaway.
Yes.
That's the biggest takeaway I would say to people. if you can get a legal practitioner, try to get one. There are ways that where you can overcome some of these these challenges. There are bodies out there which can assist with these types of things.
Yes.
And let's all come together to demand, you've been mentioning and a world-class judicial system.
Yes.
Because each and every one of us has a role to play in that. Number one, by not participating in the breakdown of our judicial system.
Yes.
But number two, demanding better.
Yes.
Demanding better of our leaders, demanding better of our judicial system. If each and every one of us speaks up and demands that,
yes,
one day I really believe that we will achieve that.
Yes, well said again, Mr. COLTART. And in the words of our former president, Asante Sana, every Zimbabwean has a crucial role to play in the creating, in the fostering, and the delivery of a criminal justice system that is world class. And thank you very much for listening to Legal Matters. I was joined today by Mr. Douglas COLTART, a human rights law expert, someone who has worked with various people within the legal field and also just contributed greatly to the jurisprudence that we have in Zimbabwe in issues that deal with human rights law and criminal law. So, Mr. COLTART, once again, thank you. You are an inspiration. Please keep doing the good work of criminal justice and human rights defending that you're doing, as you are really setting a torch ablaze that most people in Zimbabwe and that the legal system will have to recognize. So thank you very much for tuning in for Legal Matters, and stay tuned to Heart and Soul Broadcasting Services, where we communicate for change and communicate about change. Once again, my name is Tulani Mututa, orator for the law, and stay legal wise and stay tuned to Legal Matters.